Where Kenya's Deputy Chief Justice Kalpana Rawal has been granted her right to appeal in the case where she was challenging her forceful retirement. The Judicial Service Commission had argued that Rawal should not be allowed to appeal after the High Court ruled that she ought to retire at the age of 70 years, which she turned 70 on the 15th of January. Joining us now is Murimi Mwangi. Murimi, what is the Judicial Service Commission now saying after they failed to convince the Court of Appeal judges that the Court of Appeal does not have jurisdiction over this matter?
Good afternoon, Sophia. It is a ruling that, of course, sets a precedent on this very momentous case on the retirement age of judges. Remember, it has its genesis back to the High Court that issued a verdict that the Deputy Chief Justice and two other judges that had reached the age of 70 years or are supposed to retire is at the time they get to the age of 70 years. Of course, the dispute being that the Constitution, the old Constitution, initially stipulated 74 years, but the new Constitution requires the judges to retire at 70 years. And to shed some more light on this issue, I have the DCJ's lawyer, Mr. Kioko Kilukumi, here with us today. Mr. Kilukumi, what are the implications of the verdict that we've had here at the Court of Appeal?
The implications of the verdict of the Court of Appeal is that the DCJ, that is the Deputy Chief Justice, and indeed every other Kenyan has a right to challenge a decision of the High Court when it interprets or applies the Constitution of Kenya. Every citizen also has a right to challenge on appeal a decision dealing with human rights or any article in Chapter 4, the Bill of Rights chapter. Yes, in our Constitution.
Now, you've been given a hearing date for this case. It's you're commencing an appeal. What are the issues? What are the issues that you want to raise against that High Court judgment that was delivered in December last year?
The appeal has been fixed for hearing on the 15th of February 2016. The key issue is one of interpreting what Section 31, subsection 1 of the 6th schedule to the Constitution means. Does it mean that judges transiting from the old Constitution retained their 74 years as retirement age, or are they subject to Article 167 of the Constitution, which stipulates 70 years? The appeal is, does the Constitution specifically save retirement age of judges transiting from the old Constitution to the new judiciary?
Now, looking at the massive public interest in this case that has come as a result of the very first order that was issued by the Judicial Service Commission requiring the judges to retire at the age of 70, what does the determination, the ultimate determination of the appeal that is coming before the Court of Appeal mean with regard to the interest that Kenyans have in whoever is serving in the position of DCJ or the Chief Justice, given that we have a Supreme Court judge as well as the Deputy Chief Justice being affected by this case that is coming up now in the Court of Appeal?
Let me put things in perspective. The Judicial Service Commission in 2011, a matter of months after the Constitution came into effect, sat down, deliberated, and made a resolution that transiting judges will retire at the age of 74 years. It is only that 3 years thereafter, they sat again for reasons that have never become apparent why they revisited the issue. They revisited the issue and now reached a different conclusion that judges who are coming from the old Constitution should retire at 70. And it is important to realize the composition of the Judicial Service Commission. The composition is of top jurists. You have the Chief Justice sitting there, you have a Supreme Court judge sitting there, you have a Court of Appeal judge sitting there, you have a High Court judge sitting there, and you have the Honorable Attorney General. On top of that, you have two lawyers of at least 15 years standing. So you must ask yourselves, why did they reach the conclusion it is 74 years in 2011 and change later to say it is 70 years in 2014? What changed between those two periods? these are not people who are not schooled in law. These are people who are very well educated in matters of law, in matters of interpreting the Constitution. So there must have been a reason that made them shift. Probably there was the aroma of vacancies arising in the Supreme Court, and that is probably what drove them to change their minds. Yes.
Interesting perspectives coming from lawyer Kioko Kilukumi over this case for which a verdict has been delivered. And talking of the immense public interest that has come as a result of this case, I would want to speak to an interested party that has been in your case, Mr. Okia Omtata. I can see he's already here.
Yes.
Swap the microphones.
Yeah, please go ahead.
So hear a word from him. Yeah. Thank you very much for your time, Wakili.
Thanks.
Mr. Okia Omtata, you enlisted yourself as an interested party in this case. Why is that the case?
Well, the issue is just a question that the rule of law is a very important aspect in this country. And where I stand from, I always agitate that the law must be supreme and everybody must obey the law. So when the matter came up and the judge was urging that she could not go, I felt it was important to have my opinion on the to have an opinion on the issue recorded in court. So I applied. I gave my reason for wanting to join, and the High Court allowed me to join. So that's why I joined these proceedings to demand that the Chief Justice, Deputy Chief Justice, vacates office at the age of 70, as the Constitution states.
Now, without getting into the merits or demerits of the case that is now coming before the Court of Appeal, you've in previous instances raised concern about how the sanctity of the entire court process that is going to ultimately deliver a verdict on this matter. And in previous regards, you have said that judges that might be affected by this provision of the transition from the old constitution to the new constitution with regard to the retirement age should not be sitting on the bench hearing this case. Do you think that now, as the case is coming before the Court of Appeal, you're going to get justice and many other Kenyans that are looking up to this case to see a fair conclusion?
First of all, I still stand by my position, which I raised earlier, that only judges who are not affected by the decision should sit, because conflict of interest is conflict of interest. Irrespective of what kind of training you have, if you are a doctor, you might not be allowed to operate on your own child because of various reasons, not because you are incompetent, but maybe you might have an emotional attachment that may derail you or something like that. So the fact that judges who are appointed under the old constitution stand to benefit or lose 4 years is a strong issue, and we still stand by the position that the appeal ideally should be heard by judges who are appointed after the new constitution came into force and who will not be affected either way the matter is ruled. But well, since we are not the ones responsible for creating a bench, and this matter must move forward, our concerns are on record. We can leave it for history to determine, and we are ready to forge on and ensure that we uphold the constitution. And what's important, even like what happened today, where I stand from, the ball is in the hands of the Chief Justice. The High Court agreed with our position that the Chief Justice, the Deputy Chief Justice, or any judge must retire at 70. She's staying in office as a result of a non-judicial process.
Now, without getting into